Recorded from the U.S. Capitol, you're listening to the Congressional Internet Caucus Academy's podcast.
Hey, thanks everybody for joining us today. My name is Tim Lorden. I'm the Executive Director of the Congressional Internet Caucus Academy. And today's luncheon is called Verifying Kids' Age, SCOTUS, and AI Boundaries. This event is hosted by the Congressional Internet Caucus Academy, and we do this event in conjunction with the Congressional Internet Caucus itself. The co-chairs of the Congressional Internet Caucus up here on the Hill are Congressman Michael McCall and Congresswoman Haley Stevens, and on the Senate side, it's Senator John Thune. Historical note, the Congressional Internet Caucus was created shortly after the passage of the Communications Decency Act in 1996. Which was a law regulating speech back in the before the millennium turned, and members felt like they didn't really quite understand what the internet was, so they got together and did these educational briefings so that they get up to speed on the internet. And we've been doing these briefings on a regular basis since 1996. So we want to thank the Congressional Internet Caucus co-chairs for hosting this event in conjunction with us. A little bit of housekeeping. Next in September, September 25th, I think in this room, we're going to look at, we'll have another luncheon to look at artificial intelligence and energy use. So that, just put that on your calendar for the 25th. And then as far as, we have an expert group of speakers today that cover the gamut of content law, technology policy, and we're going to work through some issues today, and then we'll save some time at the end for Q&A. But to my right is Luke Hogg, who's the Director of Technology Policy for the Foundation for American Innovation. Next to him is Chris Marchese, who's the co-founder and co-founder of the NetChoice Litigation Center. And last but not least, Kate Ruane, who's Director of the Free Expression Project for the Center for Democracy and Technology. So we're going to work through a bunch of issues. I'll just briefly set the stage on why we're here. About a month ago, the Supreme Court ruled in Free Speech Coalition versus Paxton, and in that case, the Supreme Court ruled on a Texas law which aimed at keeping children away from sexually explicit content, and Kate can maybe explain better than me, but it required some age verification. If a website had more than 1/3 of its content was sexually explicit, that site had to put up some type of age verification mechanism to keep minors out and allow adults to view that content. And the Supreme Court came back, and I mentioned the Communications Decency Act back in 1996. That was followed up by the Children's Online Protection Act in 1998. And those cases went up to the Supreme Court as well. And in those cases, the Supreme Court came down with saying, well, we're going to rule these cases unconstitutional, and we're going to apply strict scrutiny because it's a government restriction on speech. And strict scrutiny is really hard to overcome from a constitutional perspective. And people in my space kind of felt like that issue was put to bed for a good, forever. But the SCOTUS decision in Paxton reimagines that standard as an intermediary liability case, and it opens up a lot of new issues regarding keeping kids safe and legislation on those issues. And age verification is the heart of it. And we're going to kind of explore the constitutional implications of age verification, how effective is it, and what other things do members want to age gate kids to be protected from. So just really quickly, Kate, I also want to mention as a resource, the Congressional Research Service, which is essentially the think tank for Congress, has done 3 part 1, 2, and 3 papers on age verification and content restriction. I recommend it. I think Eric Holmes is the author of these reports. Definitely worth the read. Very neutral, very straightforward, great information, and I would recommend you guys read it for background. But Kate, if I could just ask you real quickly, what did the Texas law require, and how did SCOTUS handle it, and why is it different now than the CDA and the Children's Online Protection Act?
Okay, I will do my best, but first I am going to support your plug for the Congressional Research Service, where I also worked for 11 years. The work they do is amazing, and if you're not reaching out to them constantly, you should be. everything they do is excellent and well-researched and thoughtful. So FSC versus Paxton. So the Texas law at issue in FSC versus Paxton required all websites, all online services that published at least a third of their content being sexually explicit content to verify the ages of everyone using their website, using either digital ID, which is not available in Texas, or a commercially reasonable age verification method, which the statute defined as either you provide your government ID to the service to verify your age, or the service could use an age verification method based on like the processing of data. So for example, like a mortgage application could be used to as a signal for what your age would be. As Tim mentioned, previous Supreme Court cases had indicated that such age verification requirements were subject to the highest standard of scrutiny possible, and therefore almost certainly were unconstitutional. What happened though was, the lower court enjoined the law. It went up to the Fifth Circuit, and the Fifth Circuit said, no, that's not right. This is just like other age verification requirements that we subject people to every time, all the time. So, you go into a brick and mortar store, you want to buy a sexually explicit magazine like Playboy, you have to show your ID. The reason you have to show your ID is because also a long time ago, the Supreme Court looked at one of these requirements and determined that sexually explicit content is obscene as to minors. Now, that's a term of art. What it means is that sexually explicit content is not protected speech for minors. They don't have a right to engage in it, they don't have a right to access it, and that means that the government can prevent them from buying it or from seeing it. And so the Supreme Court took a look at one of these ID requirement laws back in New York in a case called Ginsburg versus New York, and said, this content isn't protected for kids, and so you can require everybody to show their ID in order to obtain it. These types of requirements get what is called rational basis review, which is very, very easy to satisfy. You basically just have to say, this is what I'm worried about, and this is how I'm fixing it, and I have a good reason. You don't really have to spend a bunch of time justifying, the government doesn't have to spend a bunch of time justifying its decision or how it came to its decision or how it tailored its decision to ensure that everybody could access the speech to which they have a constitutional right. This has been different on the internet, in part because age verification is much more difficult to do on the internet. When you do it in person, people can see you. And the provision of the ID is ephemeral. It is not linkable to you in other areas of your life. But on the internet, that is different, and it is still different. Nonetheless, the Supreme Court, in a 6-3 opinion written by Justice Thomas, decided that the Texas law was not subject to strict scrutiny and was instead subject to intermediate scrutiny. And it did so for a few reasons. First, it agreed that, or it basically held that the statute was only aimed at restricting the delivery of content that is not constitutionally protected to deliver to minors. Yes, it recognized that adults have a right to access this content, but because in the court's view, it was only about restricting access to sexually explicit content which is unprotected to minors, the court basically found this was a valid thing for Texas to pursue. The way that the court gets to intermediate scrutiny is to say that sexually explicit content that is obscene as to minors, is partially protected speech. This is a brand new category of content. We didn't know about it before, but now we do. And what the court said was, this is a category of speech that the government can burden but not prohibit for various reasons. And then said that the Texas law fits into this category because it's not banning sexually explicit content. It is just requiring people show that they have a constitutional right to access it by going through age verification. The court basically says that because minors don't have a constitutional right to this content, it logically follows that everybody has to submit to age verification in order to access it, and that adults don't have a constitutional right to access it without showing their ID or without proving their age in one way or another. And so that's how you get to intermediate scrutiny. And a court likens this to another category of speech category of restrictions that have always gotten intermediate scrutiny, which is incidental restrictions on speech. Difference here, this is also brand new. This is the first time this standard is being applied to a law that is a content-based restriction on speech itself. Previous decisions that talked about incidental restrictions were about laws that were not aimed at speech at all. They were aimed at things like burning your draft card, or camping in parks. Things that clearly have some application to expressive content, but that's not what the government's trying to get at. The government is trying to get at, we need your draft card because you're subject to the draft, or we actually want to create reasonable regulations about when camping can happen. And so those laws get intermediate scrutiny and not strict scrutiny because they're not about speech. But this law is very much about speech. It is very much about stopping kids from seeing content that the government can stop them from seeing. So that is basically how we get to intermediate scrutiny, and the court then sort of easily finds that this particular law meets intermediate scrutiny. And some of the concerns that would still remain under intermediate scrutiny are pretty much dismissed by the court in a footnote, footnote 7, where the court says, yeah, it's true that this might apply to more content than sexually explicit content because it applies to websites that host more than sexually explicit content. The 1/3 threshold sort of comes out of nowhere. But they say we don't need to worry about that right now because that's an as-applied issue, and no one has told us that sites are going to gate content that isn't sexually explicit. So we can deal with that later. It's an as-applied issue, not a facial issue. And they also say that, you know, sexually explicit content that is obscene as to minors, is not this like broad category of content. It doesn't include R-rated or PG-13 movies. And we also don't have to worry about whether sexually explicit content is appeals to the prurient interest of a toddler versus the prurient interest of a teenager. We don't think toddlers have prurient interests anyway. So we probably are just looking at adolescents. But again, we don't have to decide that right now. This is all in a footnote. Hugely important footnote for us going forward, I think, in scoping what this decision applies. But that's basically where things are.
So you took my question. I was going to ask you, I intimated that this is a huge sea change from where we were back in the 1990s and the early 2000s. And we thought that this issue was put to bed by the Supreme Court. The Supreme Court just ruled, it just changed. Is it really that significant? You just stole my question.
Yes, it really, I think, so I think the scope of the decision is something we can talk about, but I think it's a huge decision, and I don't want to pretend by saying that I think it can be, you know, that I think it should be narrowly interpreted and narrowly scoped going forward, that it won't have significant impacts on people's ability to engage in constitutionally protected speech that isn't just sexually explicit content, but includes sex education, any speech that will relate to sex, the speech of the LGBTQ community, for example, I think is at risk, and we need to be very, 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 very careful about how we apply this going forward and how we understand the scope of this statute. But we do not know the full impacts of this.
So
case
Chris
yet,
and Luke, do you share the concern that it's significant? And by the way, there's a lot of people saying, finally, we have so on the other side of the coin, there's legislators that say, finally, we have a constitutionally valid way to keep material away from children. And so people on the other side are maybe excited about that. And it's not like this case is necessarily going to open the floodgates. There are 24 states that have laws for age verification already, let alone the European countries. So Chris, Luke, what do you think?
Sure. So I think, whenever the Supreme Court applies doctrine in a way that produces different results, and in the process is sort of either clarifying the doctrine, moving the doctrine, or silently overruling it, it's meaningful. And so here it is definitely a meaningful decision. It is going to have ripple effects. I think it is absolutely the case that lawmakers will try to push the decision for all it's worth and go after constitutionally protected speech for everyone. I think that is a real ramification of it. At the same time, I think it is important to note that the Supreme Court did limit its decision to sexually explicit content. So while it's true that lawmakers will use this and abuse it, it's also true that courts who faithfully apply the decision will hopefully understand it as being limited to very specific factual situations. And here, it's not just like, you have some pieces of content that are sexually explicit. It was more than 1/3. So that is a lot of sexually explicit content when you put it in the context of the internet. And so while the decision is meaningful, while it is going to, unfortunately, chill constitutionally protected speech, it is also true that, at least as written, it is limited to a very narrow circumstance.
Yeah, I would just say that first and foremost, a qualifier that, unlike my colleagues here, I am not an attorney. And so it's just like, but reading these cases, I think I generally would agree. Obviously, it's a momentous decision. It will have large impacts going forward, as pretty much, every major kind of Supreme Court decision does. But I would slightly push back against, I think, the way Kate was framing it, because I think part of this case is also discussing the difference between ends and means when it comes to the law, right? In my reading, essentially what the Supreme Court was saying is the ends of trying to prevent children from accessing obscene content are constitutional, and we've allowed states to impose means in order to set that up. And so essentially, the power of a state to protect children from accessing obscene content necessarily requires the constitutionality of the means by which to actually do that prevention, right? It's useless to have a law that says children can not access obscene content, but then to not allow the state to implement something that actually protects and make sure that children are not accessing the content. And I think that obviously, I think you have to read this decision rather narrowly, just based on the decades and decades of case law that we have around obscene content versus other content. So that's an important distinction that I would agree with Chris on. But I think that the underlying principle that the opinion gives kind of hints at this idea that if we are going to allow states or even the federal government to protect children or to do other things, the question is primarily whether that the end is constitutional rather than what the means are to, and obviously then this gets into strict scrutiny and all of that kind of stuff. But just, I do think that that's an important distinction that I saw reading this decision.
So, Chris, you're the head of the NetChoice Litigation Center, so you see a lot of these bills in different states coming up, and all different standards, all things legislators are trying to protect children from. What other types of bills are out there? I mentioned, I think, 24 pieces of legislation in the states, not to mention Europe, that are implicated by this issue. What other rules are out there that in the states about these close to this issue?
Sure. So I'll just take everyone on a very brief history of sort of online censorship regimes over the last few years that we've been challenging. So back in 2021, NetChoice, along with CCIA, sued the states of Florida and Texas because they had passed laws that basically prohibited content moderation. So at the time, a lot of people pointed out to them, hey, this is going to create a content cesspool that's not great for children at all. And lawmakers said, well, censorship is a more dangerous harm to minors. That was 2021. Fast forward a year, California tries a very similar regime. It actually imported what's known as the Age-Appropriate Design Code from the UK. It goes after every website and more or less says, the way that you disseminate content, the content that you host must be in the best interest of a child. It must be reasonably safe for a child. Of course, a child could be anyone, 2 and up. And so it would sanitize the entire internet. That was California's approach. Then in 2023, we get an explosion of age verification laws from states like Arkansas, Ohio, and so it becomes a red and blue issue where states are saying, yeah, forget what we said in 2021. We still care about free speech, but actually now we don't like the content that you're hosting, and we're going to say that we're trying to regulate online access to content that is harmful to minors. Of course, lawmakers probably have a different idea about what is harmful to minors than the average American parent, and that has proven to be the case in case after case after case. But then, after those age verification laws were enjoined, we see a little bit of nuance. Some states like Florida say, all right, we're going to prohibit people who are under the age of 14 from creating social media accounts. And then, if that gets struck down as unconstitutional, we're going to prohibit everyone 16 and under. How that is logical, I don't know, but that is something that is innovative, and we'll see how it plays out in court. And then after all of those laws were successfully enjoined, we saw a new wave of laws targeting so-called addiction. So here, states like California, once again California, are trying to get at content that the state doesn't like and is saying, if anyone is quote-unquote addicted to it, you have a right to sue. Now, I want to be very clear about this. It is definitely the case that everyone wants minors to have a safe online experience, right? It is also, for the cynics in the room, it is in the best interest of corporate America if minors also have a safe experience online. So, the bottom line aligns with the moral line. But even if we were to set that aside, this is a serious issue, but that doesn't mean that we can create, new causes of action like being addicted to constitutionally protected speech. Imagine if, President Obama created a cause of action saying that if you're addicted to Fox News, you can go after the publisher and violate that publisher's First Amendment rights. It has ramifications here that go far beyond just trying to protect minors online. So, you put that all together, and we see that lawmakers at the state level have been very creative in trying to get at content that they don't like, whether it's through the addiction causes of action, age-appropriate design code, which is really just a speech code for the internet, age verification with parental consent, which is basically proving that you're a minor's parent and signing a permission slip. How do you prove that you're somebody's parent without uploading incredibly sensitive documents, right? Like, are you comfortable uploading your child's birth certificate, your social security number? Probably not. And yet these regimes just keep getting rolled out. Again, they are innovative, but they are innovative in a very unconstitutional way.
And some of these things are speech, and some of these things are not speech.
We take the position that it's all speech, right? Like, lawmakers say, oh, this is about protecting privacy. Well, if it's about protecting privacy, why are you increasing the demands on people to produce sensitive information? And if it's about so-called design, then why is it going after speech that is allegedly harmful to minors, right? So you can say it's one thing, but in reality, how the law is put into effect determines what it's actually about. And what all of these laws have in common is that no matter the rationale lawmakers use, no matter what they label the law as, these laws go after constitutionally protected speech. And that's the big difference between the 20 NetChoice lawsuits we have versus FSC versus Paxton. So FSC versus Paxton is going after content that is illegal for minors. And it says because it is illegal for minors, there is the practical question of who is a minor. And because you have to answer that threshold question, you can use age verification. That is simply not true in the context of social media or the vast majority of websites online, where the content they host is legal for everyone of any age. Even if you don't like the content or you think that it's pushing the envelope a little too far, ultimately it is constitutionally protected for everyone.
Okay. So I mentioned that this thing is kind of exploding. Over the weekend, President Trump was in Scotland, and he was with the Prime Minister of the UK, and the UK Online Safety Act went into effect on Friday, and so President Trump expressed concern that maybe Truth Social, which is his social media site, would be affected, and the British Prime Minister is standing next to him, and President Trump says, please don't censor my site. And as far as the Online Safety Act, I don't have time to read the types of things that are just considered harmful to minors, but it includes, like, harmful to children is content that if it targets race, religion, sex, sexual orientation, there's aspects of bullying content. There's also, like, if you're engaging in violence against dogs, it's actually a list, and I can share this on Twitter later. But That's kind of in the news right now as well, and it does require an age verification system for those things, and how it's going to be applied is going to be interesting. How do you think that in the United States, up here on the Hill, these things are going to be applied? Luke?
Sure. Well, I would first say that Europe is going to Europe, like they always do this. And I was actually, just before I was talking to Kate, and this is something that the Trump administration, the State Department is very concerned about, is if the United States doesn't act on a lot of these issues, then we're going, and this is beyond kids' online safety, this is beyond age verification, this is about AI, this is about technology generally, that we are going to be forced into a box by the Brussels effect, which is essentially the idea that the major regulations that come out of the European Union become de facto laws for the rest of the world. So, I mean, I think it's very concerning to see what's going on in the European Union, but I also would caveat that to say that there's actually some positive things that are happening in the European Union when it comes to thinking about data protection, data privacy, and the ways in which that is incorporated into age verification. I know we're going to get to some of this later, but I would compare the UK's pretty god-awful age verification regime to the one that's actually been established or is currently being established in France. One of the things that the French law requires is a double-blind system where all information is deleted, right? And so I think we can get into some more of the details, but I do think that seeing some of these test beds that have gone, whether it's test beds in the States or test beds in Europe, we can see how some of these things might potentially make their way up here on Capitol Hill. There are several pieces of legislation currently circulating in these halls that have to deal with these very issues.
So why don't we segue to like the mechanism? Since I've been working in the space, which has been a very long time, this New Yorker cartoon has been, I hear it like at least once a week. Has anybody ever seen this New Yorker cartoon? It's famous. Like, people of my generation know this cartoon. It's cited all the time. And the challenge for the internet, the great thing about the internet and the worst thing about the internet is that on the internet, no one knows you're a dog. If you walk into a liquor store and you want to buy alcohol, if you look under 21, they're going to ask you for ID, and you can present a credential. It's in person. That data doesn't get stored. You walk out with either you walk out with your six-pack or you don't, depending on your age. But on the internet, that presents an incredible challenge. And the holy grail in the entire time I've been working in this public policy space on the internet is that authentication for a variety of things, whether it be to access age-appropriate content or to access systems that are maybe sensitive for cybersecurity reasons, or financial systems or anything like that, proving you are who you are is a problem across the entire internet. And even dogs can get on the internet. I've actually seen pictures other than cartoons. So I guess the question is like, people feel like right now we have the technology to do age verification, and my question is like, can you just kind of go through maybe like the systems that are out there? We have age gating, age estimation, we have third-party verification, we have credentialing, and maybe just kind of, Luke, if you could just kind of expound on that. Just
Sure. I'll run through those, and then kind of, I think there's also subcategories of age verification itself. So age gating is the system that essentially we are all familiar with right now. This is what is established under COPPA, and essentially it's just click a box and tell them that you are actually over the age of over the age of 13 or over the age of 18. No one ever really checks. It's you attest that you are old enough, and that's good enough. Or to some people that's good enough, right? Then there's age estimation, and this is what a lot of so in addition to using age gating, a lot of platforms use some systems of age estimation. So for example, TikTok, Facebook, Instagram, Google, probably in the terms of YouTube, they can do a good job of estimating your age based on how you interact online. Most famously, Instagram recently rolled out a process called Instagram Teens, and part of it's a much broader system, but part of the system is actually just like looking at your publicly posted photos and using machine learning techniques to be like, oh, you're clearly a toddler, right? That you can do that with machine learning. So that's age estimation. Then you have third-party verification, and this is kind of a weird category because it's essentially having somebody else whose age has already been verified and verify your age, if that makes sense. So let's say my mother was on Facebook and she had already verified her age. She could verify that I was overage. That's a weird one. We don't actually see that that often out in the wild. But finally, then we have age verification, right? Which is, I think, what we're talking about here, and that is using, I think broadly, the definition would be using some sort of system to verify that a person is who they say they are and that they are of the age that they say they are. That's a very broad definition. I think that there's some important subcategories there. So Kate brought up a few of them. One is uploading your identification, right? So it's using existing government documents usually to attest that you are who you say you are. They'll take a picture of your ID and they'll take a picture of you and they'll say, yes, you are the person that's on this ID within some margin of error. Another one is actually using bank account information. So bank account information, in order to have a credit card or a debit card in the United States and have a bank account that is not linked to a parent, you have to be over the age of, I believe, 18. Don't quote me on that. But you have to be over 13. So that's another system. A third system is actually a burgeoning field that is looking at open source information about you online. So for example, if you had a Hotmail email address, like, you're probably old enough to be online. So it's, and that's a burgeoning field, and that's a real fun one. But the final one is biometrics, and this is, I think, one of the more controversial systems. I think, Kate and I have some disagreements about the efficacy of this system, but in essence, it is using machine learning technologies, AI in short form, to take a photo of your face or take a photo of your hand and verify that you are, of age. And that's the biometric system. So if you go, this is something, if you've flown recently, the TSA uses biometrics to verify, so that you put in your card. In order to verify that you are the same person that is on your ID, they use biometrics, and within some margin of error, they determine that you are who you say you are. So that's like
Yeah.
the age verification landscape.
And I guess the question is, how effective are they? Like, do they work? There's a variety of different ways to skin the cat, right? Just some fun facts from the weekend. In the UK, when the UK's Online Safety Act went into effect, I think 5 of the top 10 apps in the Apple App Store were VPNs, virtual private networks. I think in Texas, VPN use went up like 1,000%, and I think in Louisiana, when that law passed requiring age verification, traffic to adult sites dropped by 80%. So, I mean, how effective is it to get at the purpose that the legislators want to do, is to protect children? For anybody, yeah.
I'd love to. So, on the internet, no one knows you're a dog. Age verification systems don't either. We filed a brief before, and I mean, like, look, everything has that. Every age verification system that Luke outlined has an error rate, and so the question is, how much of an error rate can we tolerate to access constitutionally protected speech? The answer used to be very little. Now the answer may be different. It at a minimum includes whatever is in the Texas law, and we actually don't know specifically what is included as permitted age verification systems in that circumstance. But in our brief, we filed with the Supreme Court, and also a version of it with the Ninth Circuit and another NetChoice versus Bonta case, CDT went through as many of the categories of age verification as we could, and we did it to show that every single one of these systems online is gameable, for one thing, by minors to access content that they theoretically don't have the right to see. And then B, also excludes people who have the right to access that content. So for example, if you don't have an ID because whatever reason, you're an immigrant, you are someone who was born and you don't know where your birth certificate is and you never got a driver's license, there are many, many, many people like this. Or if you are forced to use a biometric system, it it misidentifies you, and this is particularly difficult for people with disabilities and gender nonconforming people. At scale, that's a lot of people. So even if you are talking about just 1 or 2% of an error rate in every single one of these systems across each of these systems, and age verification providers do say that that their systems do have an error rate, and they make recommendations for how to address error rates or how to address age estimation that happens, within a certain age range, so like 18 to 25, to try to help deal with the error rate, but there is one, and that means that people will not get to engage with the content they want to engage with, or will not, or will be chilled. The other thing to note is the risk that these systems put us to. So there is, perhaps people saw over the weekend, there was a data leak for something called the T-app. The T-app is, maybe still is, an app that allowed women to share information about relationships that they had previously had with other men. In order to sign up for an account, you had to show you were a woman, and you could do this by either providing your image, your biometric information, or you could do it by providing your ID. All of that information was leaked on 4chan, and that data leak has been confirmed. All of these people are now at risk of identity theft and potentially of domestic violence, because this information is now accessible, including now, additionally, the content of their communications is now accessible to anyone who wants to see it, and that might include people with whom they had difficult or even abusive relationships. So we need to be aware of these things and build safeguards into statutes if we are going to pursue this path.
And Luke actually wrote a paper called "On the Internet, No One Knows Your Dog: Examining the Feasibility of Privacy-Preserving Age Verification Online." So you actually used the dog metaphor, and you wrote a paper on how effective these things can be. Is it the same today, age verification, as it was when the Supreme Court looked at this last under COPPA or the Children's Online Protection Act or the CDA?
Yeah, I mean, I think essentially nothing online is the same as it was when we were passing this legislation initially in 1996. And thanks for giving people the context for the joke, because if you don't get it, it's weird. I really respect Kate, and I respect the work you're doing, and really appreciated what you were putting out with your brief. But quite frankly, I fundamentally disagree on both points. So this is going to get a little statistical for a second. There's essentially two questions here, right? What is the efficacy of these systems, and then how do we secure them in a way that protects the privacy and security of individuals? So on the efficacy, I mean, you mentioned 1 to 2% of margin of error, but that's not really what the margin of error actually ends up being in practice. NIST looked at essentially every system of biometric age verification. The highest error rate that they found was 0.22%, 0.23%, and it's actually gotten better. They started doing this in 2023, and over the time they've gotten a lot better. And when you look at the actual margin of error for example, people of color, LGBTQ+ people, those margin of errors are significant. It's important that we note that people of color experience the margin of error 8 to 20% more than white people. However, when you put it into the context of the actual overall margin of error, that margin of error of 0.2 means that an 8 to 20% change is 0.009%. So I think the fundamental question of how much error is acceptable, it's an important question, but quite frankly, if I think that 99.9% efficacy is good enough for me. And then on the security, I'm glad you brought up the T-Act, because I think this actually demonstrates why we need some legislation around privacy and why we need legislation around age verification systems, right? So one of the reasons that this hack was so bad was that the T-App stored this information in a way that it was so easy, it was ridiculously easy to get access to. And they were not being held to the fire for the basic cybersecurity hygiene. Every single age verification law that I have looked at has some requirement for data security, data deletion, in order to protect individuals. And then we can get into like comprehensive data privacy regulation. But I think that the long story short, like I do think that it is possible. I think that the systems are efficacious, and I think that we've solved the security problems too if we just do it well.
Let me go to Chris in a second, but I will note that in 2 hours at 2:30 on the Senate side, Senator Marsha Blackburn is holding a hearing on omnibus federal privacy legislation, which we still have not done yet. So I guess I'll go to Chris, but should we pass the privacy and security legislation first, or?
So to answer that, first I would like to respond to
Yeah.
Luke, which is,
Please.
yes, the technology has changed over the last 2 decades, and he's right that the internet today looks different from just 5 years ago, but human nature has not changed. I mean, I don't know about you, but I was a little freaked out when he was describing all of the different ways that websites can, sort of merge data from across the internet to have a portrait of how old you are, right? Like that sounds pretty much like surveillance. And the more we unroll that, the more data that the government is collecting on us, first of all, it eliminates anonymous speech as a general matter. That's out the window. But then second of all, that data is putting together a portrait of who we are, which websites we're using, if it's leaked, right? Like we saw that data breaches are increasing. So if you know all of this, if you know that your data is at risk, you might choose not to engage in constitutionally protected speech online, right? That's human nature, that you might say to yourself, you know what, I don't really want my family, my neighbors, my kids, friends, parents knowing what I'm doing online, especially if everything you're doing can sort of be linked, like your searches and so forth. So I think, yes, the technology has changed, but human nature hasn't. And I think to Kate's point, we really do have to ask ourselves, just how much risk are we willing to accept? How many flawed programs, how many people whose constitutional rights are chilled are we willing to accept? And I think it should be incredibly small. So yes, technology will continue to adapt, it will improve, but we're not there yet. So should Congress pass a national privacy law? Absolutely. And I would recommend to all the staffers in the room that you reach out to Tech Freedom. They're a nonprofit that is doing a lot of hard thinking about how to sort of adapt to a post-Paxton world and do so in a way that still protects privacy and minimizes the risk to free speech. I don't have a good answer off the top of my head, but I definitely think that Congress needs to focus on a national privacy law that preempts conflicting state laws. Because keep in mind, all of this is being billed as privacy protective. No way. No way.
If I can just respond briefly to what Chris has said. I completely agree with you. I fully want an anti-surveillance system, and I want people to have privacy online, right? But I think that you're quite frankly neglecting the fact that the companies are already doing this, right? These data systems already happen, and the way that we solve that problem is not by quashing attempts to actually give people more privacy and give people more control online. It's by actually doing those things, because the companies aren't the surveillance capitalism, the surveillance system that has been established by these companies is going to continue until we do something, until we either change the economics or change the law. The economics aren't going to change very quickly, so I think that we need to look at changing the law.
And do you guys have any questions? Because I can go to the audience for questions. So if you guys have any questions, tee them up. I have a question about AI companions. There's a few pieces of legislation in the states about banning kids from getting access to AI companions like Grok's AI and things like that. But think about questions. In the meantime, yeah, go ahead, Kate.
I just want to sort of briefly respond to both Luke and Chris and say, agree totally with Luke that there's nothing stopping policymakers, and I would greatly support all kinds of privacy protections, especially now that age verification is allowed to be required. Absolutely, we should be doing everything we can to ensure that, like, whatever technical specifications are needed to ensure privacy and data deletion when those systems are used is done, and that the requirement that the data that goes into the system be of high quality and ensure that people can access the speech that they're allowed to access. And I want to go back to one other thing that Luke said about ends and means. I agree with that as far as FSC versus Paxton goes. I would just say that, like, it's really actually not different from previous ways that the court has looked at age verification, in that protecting children from offensive content or from sexually explicit content has always been a legitimate end of the government. No one has ever questioned it. No court has ever questioned it. No Supreme Court opinion has ever questioned it, to my knowledge. The difference here is that the court accepted a much weaker justification than it has accepted in the past, which is going to chill a lot more speech. It is accepting of the chilling of a lot more speech than it used to accept. And to me, you know, online freedom and the exchange of information is really important. And the court took a step in the direction of weakening protections that have long existed by lowering the standard. But that does not mean that there is no circumstance in which the high standard, strict scrutiny, could be met by an age verification requirement, which is what Justice Kagan says in her dissent. She would have required Texas to do more, to write a tighter statute that was more protective both of everybody's privacy and of everybody's right to access the content that they have a right to access.
So anybody have any questions? Right here in the front row, if you just say who you are. I'll try to repeat or we can repeat the question as we're answering it, because there's no microphone.
I hear what you guys are saying with respect to cyber protections for like identity verification, and there's a lot of risky stuff to occur, like benefits for one. I know they do a lot of stuff for identity verification. From each of your perspectives, what is the very acceptable minimum for cyber protections for data required from identity verification, and how confident would that very acceptable minimum to you be? Like how does that impact this practice?
Sure, I can take a stab at that. I think the bare acceptable minimum would be to actually look at the IRS's rules so if you want to file your taxes online, you have to like go through, I think it's like ID Me. There's a couple of different firms that do this. But within the contract of the IRS, and I don't know the specifics off the top of my head, that's where I would start to look. I think the real basic line is that quite frankly, you need to make sure that you delete any information that you get as soon as you're done, right? Because the way that we can establish these systems is you can get your information and they verify it quickly. We can talk afterwards about like the ways you can do that with cool encryption and zero knowledge proofs. But then as soon as that information is done, all you need is a binary signal that says, yes, you are the person you say you are, or no, you're not. And that should be the only signal that remains in the system, in my opinion.
So the problem with, I agree that the data should be deleted as soon as it's used, but then if you do that, you're requiring the user to upload the data every single time they go to use the website, right? And so you're actually compounding the problem on a different side. So I would say that as of right now, technology does not exist that makes me confident that this could ever be done in a constitutionally protective way. But I do think, to Luke's point earlier, technology keeps evolving. So I would say that once there is enough tech out there, and not just the tech, but also laws in place, as well as technology that supports the security behind the technology doing the age verification, then we can have a more meaningful conversation about how to implement it.
Question over here.
Can I answer since you asked
sure,
all three of us?
yeah.
I want it to work the way it works when you walk into when you try to get into a bar, right? Where they only see just as much as they need to see. It is ephemeral, and they don't get to keep it, and it's not linked to where you go next. So those are some of the things, and some technologists say it's technologically possible, but it's not happening as much as it should be, and policy at this point needs to step in to encourage it, I think.
Question?
Yes, so just to talk earlier about how if you don't get ahead of the EU regulations, then their regulations are going to kind of become de facto law across the globe. I'm curious, even if we do get ahead of these regulations, are these still not going to affect the growth as companies try to enter the EU markets? And then how do we have more free speech despite regulations?
Sure. So, NetChoice is a trade association of America's leading tech businesses. So this is an issue that we are dealing with in real time. I would say that the United States government should be leading here, and the Trump administration is, right? Like Trump just this weekend was pointing out that his own website might be covered. So I think the more that the United States government stands up for free speech and also American companies, the likelier it is that the EU backs down. And like we saw this with both Canada and the EU backing down on their digital services taxes. So I think that's one way, but I also think that American companies have an obligation to support free speech. And we see this with X, for example, standing up for free speech in Australia, even though there's no First Amendment there. They challenged a censorship law there, and they're doing the same in Brazil. So I think it's, twofold.
The only I completely agree with Chris. The only thing that I would add is I actually just came from meeting at the State Department, and one of the things that USTR and the State Department and the people that are engaging with Europe on a day-to-day basis tell us is that one of the biggest problems is that if we don't have something to go to and basically push them towards a standard, then they feel more emboldened to go and do things. So that the example that was given to us was actually the Take It Down Act. That the Take It Down Act served as a standard that they could finally go to Europe and say, this is what we're doing about this problem, and you got to get in line. You're never going to stop Europe for doing everything that's crazy, but if you get ahead of the ball, then you're, in my opinion, in my experience, the European Parliament tends to fall in line. Where you've seen Europe go really crazy are all in these places that the US has lagged behind in actually creating standards.
And it's worth noting that, if I may, that when it comes to free expression and speech, the United States versus the rest of the world, particularly Europe, the First Amendment guarantees speech at a level that's so much higher than every other European country. We could have had a panelist in here from the United Kingdom, and they would say that they're so much for free speech. In fact, we're so much for free speech, we gave it to the Americans in 1776. The reality is that their standards for speech are much lower when it comes to free expression, and that's just a fact. Question?
Yeah, thank you, everybody. Mark Brennan with Political Impulses. So, even though the court upheld the Texas law here, there have been a number of state laws that have been annoying that choice has way on a number of those. I'm worried that this decision will empower states to push the boundaries a bit and look past more likely unconstitutional laws. And I just want to see what the reaction is.
I was just going to say, I think this is one of the beauties of the laboratories of democracy. If they pass more unconstitutional laws, then the lovely gentleman to my right is probably going to sue them, and they're probably going to win, and probably that law is going to get struck down. I don't know if you have any.
Yes, unfortunately, I think just as the EU will consistently find ways to regulate in dumb ways, states and lawmakers will consistently find ways to regulate in unconstitutional ways, and this decision, I think, gives them enough fodder to think that they are doing something constitutional when in reality they are not. So I think we will likely see more bad laws, more lawsuits. In an ideal world, lawmakers will use this decision to focus in on the content that is actually at issue in the case, which is sexually explicit content for minors. To the extent that they go beyond that, which is very likely going to be the case, I hope Congress sort of comes in with a national privacy law, and then litigation can make up for the rest.
And I think it's worth noting, we've been talking about the states a lot, but up here, there's a lot of pieces of legislation that are teed up. I don't know whether lawmakers were waiting for the Supreme Court to decide on this before passage, but on the Senate side, Senator Mike Lee has the App Store Accountability Act, which would require app downloads to be age appropriate. On the House side, there's the Screen Act by Representative Mary Miller, H.R. 1623. How do you feel about that as far as where things are going with regard to legislation up here, and how should staff think about this? Anyone?
So I think a lot of the ideas that are currently percolating in Congress are also unfortunately unconstitutional. COSA is the biggest one, right? That is blatantly unconstitutional. We have 20 different lawsuit decisions that all basically bear on it. But even setting that aside, I think so long as Congress is focusing on actual privacy legislation, that is a very meaningful route to go. Anything that starts to look at content outside of sexually explicit, you're now in the no-go zone. So I personally have not seen any proposal from the Hill that sort of addresses what we're talking about in a constitutional way, but if there is, please send it my way.
So I think that there's so much percolating at the states that it just feels like Congress is going to act sooner or later on kids' online safety. Disagree with Chris. I think the Kids Online Safety Act is constitutional. However, I'm not an attorney. Don't take my word for it. I think the most heartening thing is actually looking at Senator Lee's push, and I think Chris actually brought something up earlier that I'm very concerned about, and that's where do you do the verification, right? Like, it is a horrible system to have every platform and every app have to do their own age verification. It is a much better system that Senator Lee has proposed and that we have endorsed in our papers that does this at the device level, the operating system, the App Store. Essentially, then you just do it one time and you're done. And then all of the nitty-gritty happens on the back end. It makes it more secure and it makes it better for the user experience.
And all these apps are rated, some are rated, depending on your Android or Apple, rated 13 and under, teen, 14 and over, whatever. But is requiring that in order for that to work, that labeling has to happen, is requiring that labeling, is that constitutionally protected speech?
Requiring labeling is compelled speech and therefore raises significant constitutional concerns. Everyone thinks of movie ratings, for example. Those aren't required. They are an industry standard. The App Store ratings are also an industry standard. And the question that I have when I think of App Store age verification, requirements for App Store age verification, relates back to what we've been talking about at FSC versus Paxton, which is how much speech does this apply to? If it is the whole internet, who is deciding what is appropriate or not appropriate for everybody, children included, who are not monolithic? I think that those issues are raised and raise constitutional concerns and frankly need to be dealt with more specifically in some of the proposals that you raised.
Let me go for one more question. On the back there.
So there's actually a success story on this front, which is Florida passed a law that requires digital literacy education in the public schools, which also includes creating like websites that have easy explainers for parents. Because one, like, just so everyone here has probably seen and knows, like, the social media platforms have been unveiling ever more like security and safety features, right? And so the problem with that, though, is that now parents feel like there are more options than they know what to do with. And so in those cases, it really is helpful to, one, make them aware of what's out there, but then also, two, help them sort of navigate through what is going to be best for them and their families. But it is absolutely the case that parents should be and must be in the driver's seat on this front. In decision after decision after decision in joining age verification laws in our lawsuits, judges have said parents are the ones who should be making these decisions, not politicians.
Well, let me just do a quick lightning round. I guess we started off by saying this is really significant. Things are happening. Chris, you've been very busy. You're going to get busier. What do you think is going to happen, just in a real quick, down the line, in the next 2 years when it comes to this issue in the states, the federal level?
Sorry, down the line. So I think, well, we're already there. The NetChoice just filed an emergency petition to reinstate an injunction against a Mississippi law which bans minors' access to social media platforms without parental consent. So I think the next case is that, and it's coming soon.
Yeah, we're living it in the moment. I mean, right, 20 lawsuits, and we're likely to see more.
Yeah, I think I agree with Chris, right? Like, more states are going to pass more laws. NetChoice and other people are going to sue to block those laws. Some of them will be struck down. I think the Paxton decision indicates that some of them will be upheld. And I think it just demands federal action on not only age verification, but also on data privacy more generally.
So I didn't get to my question about AI companions, which I really wanted to get to, but I promised you guys an hour, and we're done. I wanted to thank my panel. I want to thank everybody for coming. Thank you all so very much.